Karen Felicia Nance is joining our conversation. C.K. Hoffler is still with us. Karen, what stuck out to me with this initial group of questioning, 6 of the 20 people either knew Marcus Arbery, Ahmaud Arbery, or one of the McMichael family members. This is a small community, and that's making this a more arduous process, is it not?
Absolutely. I've heard it described as a fishbowl. Somebody knows somebody, they live next door to somebody. It's such a small community that it's almost impossible to sit as a juror in this county and not know something about the Ahmaud Arbery or the defendants. Absolutely.
CK, if you know one of them, you're out, right? Or no?
No, you're not automatically out if you know them. It depends on the depth of the relationship. I mean, if you're related to them, if they're next door neighbors, if you've done business with them and all that, that's different. But simply knowing someone does not automatically excuse you, particularly in a case like this. The prosecutors and the defense, they've got to delve into the nature of the relationship and see if they can either insulate or get rid of a juror for cause. Getting rid of for cause means the relationship is too tight, they've got a bias, they're predisposed, and they would not be able to sit and look at the facts of this case and the evidence in this case and follow the law because of that relationship. So no, you're not automatically excused, but the prosecutors and the defense are going to have to delve deeper.
Yeah. So now what will happen here is that the prosecution will finish with the witness list. Defense will have an opportunity to ask some questions. Then it's on to the individual voir dire, taking what they've heard from these paddles being raised, and asking more questions. We want to thank C.K. Hoffler for her time, as always, her valuable time this morning. Appreciate it. We're going to be back with much more. We're going to check back in for more on jury selection. We'll check in with our Chanley Painter, who was at the courthouse as well, plus much more. You're watching Court TV. Your front row seat to justice. Stay with us. Welcome back to Court TV, top of the hour. Glad to have you along with us as we start off another week together. Jury selection back underway this morning in Brunswick, Georgia. We'll take you there live in just a minute. We're finding potential jurors to sit in judgment in the trial of the 3 men accused of killing Ahmaud Arbery. It's entering week 2. Last week, the court was able to get through 3 20-person panels. This process could spill into next week now. Attorneys, in fact, the judge has said, hey, to a pool of jurors, we're going to need you that 3rd week. Originally thought they'd get it all done in 2 weeks. Maybe not the case. Court TV legal correspondent Chanley Painter is outside the courthouse in Brunswick. And Chanley, let's start with a quick update where we are, where we need to get in terms of this process.
Certainly will. As you've been showing, there is a new panel of about 20 prospective jurors being inquired by the prosecution, about to be asked questions by the defense, and they're raising their hands about certain questions. And then we will go into that individual questioning phase after general voir dire. So that is undergoing today. But last week, after several days of jury selection, these attorneys were able to qualify 23 prospective jurors. Now we need 64 total before the attorneys can start exercising their peremptory strikes. The goal is a jury of 12 with 4 alternates. Likely, Ted, this could extend throughout the rest of this week into next week if they don't pick up pace and qualify more jurors per day.
One of the pretrial motions that still hasn't been dealt with, and there are several still before the opening statements begin, is this use of force expert that the defense wants to bring in. They want to say, hey, let's bring in an expert that could talk about when you should use force. The prosecution does not want this individual to testify.
You're exactly right. The prosecution filed a motion in limine concerning the defense use of force expert in late August. But just last week, the defense of Travis McMichael responded to this motion, trying to convince this judge to allow their use of force expert, who would be a retired federal law enforcement officer. Now, here's what the state's motion in limine basically argued to the judge. It says that there are no law enforcement officers involved in the shooting of Ahmaud Arbery, no use of police force at any time during the incident, and they say that an expert would inappropriately bolster the defense's case and would even serve as a proxy in the place of the defendant actually taking the stand and testifying himself about what he was thinking and feeling during the encounter. And they also say that it may lead the jurors to assume that this incident actually involved a legitimate arrest if the defense is able to present an expert to talk about the legitimacy of it and the use of force. Well, the defense just responded, like I said, and they said an expert is relevant to explain the state of mind, particularly Travis McMichael, the one who did shoot Ahmaud Arbery. They also say that his Coast Guard training and experience informed his decision-making in the minutes and seconds of that incident. He was in the Coast Guard for 10 years. He has the same training as this expert would explain to the jury. And they also said this expert wouldn't go to the ultimate issue of the case on the reasonableness of Travis's actions. That would be the decision of the jury. But I also thought it was interesting, Ted, because the defense response actually goes through the training that Travis McMichael had, and this is what the expert would actually educate the jury about. The use of force continuum, perception reaction time, de-escalation techniques, restraints on the use of deadly force, weapon retention techniques, the ability of an unarmed person to inflict serious bodily injury and to continue to inflict serious injury even when that person is injured. That's key here. Also, the determination of probable cause, which is also a big issue for this case. So if the defense is able to have this expert, that would be a win for them.
Yeah, absolutely. You think about that goes back to this theory that the defense has and the strategy of wanting to keep the jury focused on those moments about the struggle of the gun and concentrate on that portion of the video. This defense expert would likely go through the video just like that, correct? I mean, this is a big one of several things that the judge still hasn't ruled on, but he's got some time, right? I mean, as long as these rulings are made before opening statements, the attorneys know what they can say in the opens. That means there's some several days ahead, correct?
Absolutely. There are several outstanding matters. This is just one of them. In fact, just to mention, the prosecution also handed over a CV of a use of force expert for the state, Ted. Now, that's likely going to be a possible rebuttal expert if the judge does allow the defense to call its own use of force expert. So really, at the end of the day, this trial could come down to a battle of the experts and who this jury believes. But with jury selection moving so slowly, the judge does have some time to really take up these matters, and there are at least a handful of decisions he will need to make before opening statements.
Yeah, critical decisions that need to be made in the next few days. Chanley, thank you.